Then we get to Rule 3.4, witnesses. The witnesses will remain in the courtroom so that they can learn and watch. That's Rule 3.4a. Big Rule 3.4b for attorneys to know. 3.4b, attorneys, you must know this rule. 3.4b, witnesses may not respond to other witnesses' testimony that they've been in the courtroom watching. As stated in the stipulations that they could. I've never seen a stipulation that this witness could respond to testimony that they've seen live on the stand. So 3.4b is about the witnesses hearing other witnesses testify live that day. 3.4d is regarding the witnesses being asked to testify to the other witnesses' statements. 3.4d provides that a witness is not allowed to testify about another witness's statement. So when the other attorneys are trying to ask your witness to testify, well, this other witness said something in their witness statement. What do you have to say about that? You'd stand up, objection, Your Honor, under Riverside County Mock Trial Rules 3.4d, the witness cannot be asked about the statement of another witness. You'll see up, well, I'll post it, the fact situation, witness statements, stipulations, and exhibits are the official case materials and are the sole source for that witness's testimony. That's 3.4c. 3.4d is regarding what attorneys are trying to solicit or elicit from the witness. So 3.4d provides that the attorney can't ask questions to get the witness to talk about some other witness's statement. The reason the witness can't be asked about either the other witness's testimony or the other witness's statements is because of Rule 3.4c as to what is the record for your witness who's on the stand. The witness's record that they can testify to is their own statement and anything they would reasonably know from the mock trial fact situation, stipulations, and exhibits. So that's the reason they can't be asked about these other things, the other witnesses' statements or testimony in the courtroom. Very important for you to know those three things, especially if you're an attorney. If you're a witness and you're asked about another witness's testimony, it'd be nice for you to know, I'm sorry, under Rule 3.4d, I'm not privy to information from the other witness's statement. 3.4e is what are those statements that you have in your case packet. 3.4e says that they are considered to be statements given to the police by the witness shortly after the incident happened. Now the timing is not mentioned in the rule, but as you read everything, you'll realize that those statements were given pretty shortly after the witness was somehow involved in the incident that came along to bring us to this courtroom setting. 4F is that you have your 4 witnesses for your side and you can't treat any of them as hostile, meaning you cannot ask them questions in the format of cross-examination questions. 3.4G and H have to do with making sure you call all the witnesses. Each of your 4 witnesses on direct must be called. That's why you need to be very mindful of time. Only use the time that you've planned out. Don't do a lot of redirect and waste your time because you may not get to your last witness, and it's a huge penalty. The witness gets 1 score and the attorney for your side gets 1 score, or the cross-examining attorney will get a score of 10 against a witness that they didn't get to cross-examine. So it's just a huge problem that you really need to pay attention to time and make sure you call all 4 of your witnesses. 2 redirect questions at max for your witnesses. You keep the time down and make sure that you call all the witnesses. And it's the same for cross-examination. If one team uses all their time cross-examining 3 witnesses and don't get to the 4th witness, there's a big penalty for that. Rule 3.5, unfair extrapolation, is in the case packet, so we won't go through it here.